So please help me welcome Michael Kaufman for his presentation today.
Thank you. We're live? Thank you all for coming, and everybody online, appreciate your attendance as well. I'm from New York originally, so I kind of speak fast. So you can just stop me if I'm going too quick. So my name is Mike Kaufman from Comply Right Distribution Services. What we do is we supply and create products to help employers manage their employees in a compliant manner. So for anywhere from hiring somebody through all the life cycle of that employee to termination, we create tools that are written for the small business owner to make your job easier. You should be focusing on your selling whatever you're selling, the products that you're selling, getting the best people to work for you. And there's a lot of compliance hurdles you have to overcome through that process. So the products and services we offer help maintain that and keep you guys in compliance and avoid a headache before you get one. So what I like to, a quick overview of what we're going to cover. I call it avoid hiring a lawsuit. Okay? How do you avoid hiring a lawsuit? You do the hiring process correctly. You do it compliantly. And you follow up throughout that person's life with your company. And hopefully they're there for a very long time. Okay? There were specific things you have to do. There's really two things on this list that you have to do as an employer. The first one you have to do is complete the I-9 form. That's a mandatory. The other thing is you have to, if you have an employee, you have to post your labor law posters. And I'll get into why you want to do that. The other items really are, what you should be doing. So getting a good job application is key. Interviewing properly, that process of the interview process and using that job application. Hiring and onboarding the person and completing the I-9. And then having your labor law posters up and kind of getting a quick overview of the federal and state laws that affect you. Most of the people here in the room, I assume, are from California. And online, they're from all over the country. So I'm going to speak more generally about federal law. And when you get state-specific, I'm an attorney, but I practice in Florida. I used to practice in Pennsylvania and New York. So I don't have that much experience in California. And California is really tough, okay, for employers. So you got to be really careful. There's lots of rules and regs you have to follow, okay? Job applications. If you guys are hiring or not, if you have a retail store, you should have a compliant job application. It sounds like, well, why do I need a job application? Well, you want to get the right information from anybody that you're trying to hire. Now, a lot of people take resumes. Resume is great, but it doesn't give you the full breadth of information you might want to ask that applicant. Okay? So you want to have job applications on site if you're hiring. If you're not hiring and you don't want job applications, don't have them there. Because what will happen is your person, somebody will walk in, and they're your cute guy or cute girl, and, oh, yeah, we're hiring, and they hand the application out. And then somebody comes in that's not so much or they don't like them. Oh, we're not hiring today. And they're like, well, why are you discriminating against me? That can happen. So if you're going to hire, have the applications, have a compliant one. Require that every applicant fill it out, even if they're your brother-in-law. The key with hiring properly and avoiding litigation and lawsuits is treating everybody pretty much the same. If everybody's applying for a job as a cash register clerk, then everybody should be filling out the job application. The same one, okay? Make sure it's signed by the applicant. Why? Because you're going to have disclosures in a good job application that are going to protect you. You're an equal opportunity employer. The job application is only good for for a 30-day period. Things that are going to protect you from any possible litigation down the road. Key one, and this is very big. When you're interviewing, do not write on the job application. There's a case where during the interview process they wrote down gray hair, balding. Okay? Now, they weren't doing it to discriminate because the gentleman happened to be older. They were just trying to remember the applicant. But he didn't get hired. They hired somebody younger. He brought a lawsuit, and in discovery, the lawyers asked, like they always do, for the documentation, and it said right on there, gray hair and balding. So they settled that case pretty quickly. You just want to really, that's a grenade that people step on all the time. Pay attention to blanks and gaps in employment. So look at the application, look what's missing. If your application asks about criminal history and they don't put not applicable and it's just blank, you might just want to inquire about it, all right? Because a lot of things that are missing are very telling. And a lot of people don't want to put down something negative. They just rather avoid putting it on there. And then you want to maintain that application for 2 to 3 years. You want to keep it secure because most of them request a Social Security number. So you want to keep that. Why do you want to keep it for so long, for a couple of years? In case you're sued by somebody who says, well, you don't hire bald people. That's not a protected class, but let's just say it is. And you say, well, I had 1,000 applicants, and you're the only bald guy that applied. So I'm not discriminating. It was just what it was. So your class of people that you're hiring is not limited. What makes a good job application? You want an EEO statement. It says you're an equal employment, you're under the EEO laws, and you're going to comply with the federal statute. You want a job application that applies to your state. California has specifics that you want to have as a California applicant. New York has certain disclosures. Texas has certain disclosures. Each state has some 26 or 28 states have particular laws you have to follow if you're taking a job application that you have to have on there. So if you're using a general one, it's going to be hard to be compliant in all those different states. You want one that's attorney reviewed, and you want to have one that says at-will employment. It has to say on there, no matter what happens, you're an at-will employee.
Can I say that?
Yep.
Okay. Just real quickly, attorney reviewed means the form itself, not each application that gets filled out.
Yeah. So the question was, is it each application that has to be attorney reviewed, or is it the application itself? It's the application itself. And the reason you want to do that, and what you'll have is next to the attorney reviewing the application and it being compliant, you have to have faith in that application. And be careful when you're going to a store to buy a job application. If it's got dust on it and it's on the shelf, it's probably been there for 3 years. It's probably not compliant, just because the laws change all the time. So just be careful of that. I'm not saying it isn't compliant, but I would just be, if it's got 2 inches of dust on it in the store, I probably wouldn't buy that job application. Stating that if you lie in the application, it's a reason not to get the job, or it's a reason to get terminated if you're hired is something you want to have on that job application. And remind the applicant is only good for a set period of time. And criminal record questions. You're allowed to ask about their criminal record. Very state specific. Again, what you're allowed to ask, how you ask it. Not about arrests and that sort of thing. And you usually have a disclosure that says it may not be a bar to employing you. But I put a note up here, negligent hiring. There are certain types of jobs you're hiring for that you want to do a criminal background check. It may be required in your state if they're working with the elderly or with children, right? You also want to do it if you're hiring somebody that's going to be driving one of your vehicles. Wouldn't you want to do a background check on them as far as criminal record and their driving record? Because otherwise they have 5 DUIs, they hurt somebody driving your truck, you may be liable for that. So, and there's a claim called negligent hiring. And there's actually boutique law firms. That's all they do is go after employers for negligent hiring.
So is what you're saying is what you're saying that even though it may not be a requirement of the state for your own sake, you should look at what areas you're at risk in just to protect yourself?
Yeah, if you're hiring somebody that's going to be going into somebody's home,
as an example, that's perfect.
You don't want somebody who's got larceny convictions.
Right.
It's not a good idea.
And it may not be a requirement of the state. Okay.
Yeah, it may not be a requirement, but there may be a requirement.
But you still want to have due diligence.
Yeah, there may be a requirement in that state as far as how you ask about criminal records and how you disclose the backgrounds that you do, and we'll touch upon that. There's lots of rules and regs
Michael,
about that.
just really quick, there's a couple of clarifying questions from online. One is, can you say again what at-will means? And the other is, what exactly is an I-9?
Okay. So I'm going to cover I-9s. An at-will employee means that as an employee, you can be fired or terminated for any reason, any time, whenever you as the employer want, and they can quit whenever they want. There's no contract binding you. So you don't want to make your job application into a contract. or if you want an at-will employee. Now, you may want to enter a contract with an employee depending on the job you're hiring them for, but most smaller employers want at-will. That means you can fire somebody for wearing a purple shirt, but you don't like purple. You don't have to give a reason. You could just do it. Okay? Doesn't mean there won't be litigation about the reason you did it, but you have the right to do it, and they have the right to quit. As far as an I-9 form, the I-9 form is the government form to verify whether you're legally able to work in the United States. Notice I didn't say if you were a citizen or if you have your green card, or don't ever ask those questions. The issue is whether when you hire somebody, are they legally able to work in the United States? They could be on a visa and they can work here. They can have a letter from DHS and work here. There's lots of ways you can be working here without having a green card or without being a citizen. And asking those questions is a big no-no. Never ask those questions in the hiring process. You can ask if they're legally able to work here, but don't ask where they're from, do they have a green card. Bad questions to ask. Tons of litigation around that for discrimination. Yes? So the question is around H-1 visas and requiring or asking about that in the hiring process. It's a different area. As far in the second part of the question was about whether those expire or not, and what do you do about that? Well, in the I-9 process, if you're taking in some of the documents, and one of those documents has an expiration date, you can't not hire that person because it's going to expire in the future. But you have to be able to remember to go back and get the updated documentation to keep it going forward, and that's on the employee to do that. So we're moving really fast here out of time. So real quick, don't ask about their pregnancy, their arrest record, whether they're a citizen, if they're going to have kids, if they're disabled. Don't ask if they're disabled. Ask if they can do the core functions of the job. When you're interviewing, focus on the job requirements. Don't focus on the person. If they start telling you stuff about their medical issues and their family and their children, shift it over really quickly back to the job, the functions of the job. That's your focus when you're hiring, not that person's personal problems or issues. Those can get you into trouble. Don't do all the talking. Let them speak. You'll learn more. And don't ask yes/no questions. Okay, real key. The key in the interview process and to not get sued is treat everybody equally, fairly, and follow the law the best that you can. Okay? I touched upon the I-9 really quickly. The I-9's changing. And this is the I-9 form. It's now 8 pages. Okay? As of May 8th, you have to start using the new I-9 for new hires. Never do an I-9 unless they're being hired. And do it the first day they come in. Okay? And that's when they're going to bring that documentation to you. Very important on the I-9, really quickly, don't ever white it out. If you make a mistake and they haven't signed it yet, discard it. If it's just in the process, I messed it up, then give them a new one. It's just a form. But if you find a mistake, cross it, fix it, date it, and signature. The government doesn't want to see whiteout. Okay? Fill in all the dates. Don't over-document. The I-9 process is interesting. It protects the employer in a sense because it talks about hiring people that are able to work in the United States. Okay? And it also protects the employees because you can't discriminate based on my national origin or that I'm not a citizen, but I can work here. You can't not hire me because I'm not a citizen. So it works both ways. And with all the immigration discussion going on right now, with the Senate moving a bill forward, trust me, the I-9 process is going to be watched more closely, and they may have to start doing what's called e-verify as employers, verifying the information that person is giving you, which gives you further protections. So again, don't over-document. It's one form from Group A or one from B and one from C. Don't do 7, because then it's like, why did you ask me for 7? And that other person you only got 1 from. Are you discriminating against me because of my status? You can't tell them what forms to bring in. Okay? Also, one other key in the I-9 form, keep it separate from your employee file. Do not keep it in there because you don't want your manager just to know where this person's from. At least you don't want it to be disclosed in your files. You want to keep it separate. Also, if you're audited, you don't have to turn over all of that file, just the I-9 file. Okay? And then you have to. There's a period of time you have to keep it for, and you just want to make sure you maintain that file. It's 1 year from the date of hire, or 3 years. Right on the bottom. Keep at least 3 years from the date of employment, or 1 year after an employee leaves the job. So it varies depending on when they were hired, how long you keep the form. But that's key because you can be audited. Yes.
Just for my information, is I-9 needed for all employees or only for employees that's not a U.S. citizen?
No. It's every employee U.S. You should never know whether they are or aren't at the point that you're hiring them. That's the key. So everybody that's going to be hired by you has to fill out an I-9, whether they've been living here since the Plymouth, at Plymouth Rock. They have to fill it out. You can't discriminate.
And also the size of the company doesn't matter.
Does not matter. Every employer. This is mandatory for all you guys. If you have one employee, you got to fill out that I-9.
Okay, thank you.
Okay. I'm going to go quickly on labor law posters. You need to post them. The notices that go to applicants and employees. You guys know what's in your break room. Minimum wage. You have to post both federal and state, depending the state you're in.
We had a couple people online asking if they don't have a physical location for their business, where do they post these?
Okay. Good question. If you have, let's start with you have to. If you have a physical location, an office, you work out of your house, your employees show up there, and you have to have employees. If you're working for yourself, you don't have to post to yourself. But you have to post, let's say, in your garage where you run your business from. If you have no physical location, then you ought to be disclosing that to them in a paper format. In other words, get the forms and have them sign something that they've seen them. There's no hard and fast rule if there's no physical location. We have some solutions around remote workers, electronic solutions, but they haven't been signed off by the states, and even the Fed is a little iffy on that.
There was also one more quick question, which was, is an I-9 necessary for independent contractors?
I would get it for everybody because you're not sure. First thing you have to understand is, are they truly an independent contractor? I think the last person spoke about that. So I would be very cautious in whether you're able to even pay them. But if you just called everybody in your gardening business an independent contractor, and they're not legally permitted to work in the United States, you're going to be in trouble. Okay. Any other questions? I think we're kind of tight on time, or we got a couple more minutes? Okay. So why do you want to post labor law posters? A couple interesting things about labor law posters, or about just hiring employees in general. We did a study with a Florida university a few years back, and we quizzed small business owners about compliance. And like 95% of business owners, they want to be compliant. They just don't understand. Okay? And there was a study by another university, and they look back at it, and people that feel like they're treated fairly and know their rights actually sue their employers less. So having your labor law posters up is actually a good thing. Your labor law posters are all your federal requirements and all your state posters, minimum wage and workman's comp and all those things. Having those up, you need to have it if you have one employee, and it's good because it discloses their rights. And from a legal standpoint, there's case law in several circuits where I go ahead and I fire somebody. They worked for me for 5 years, okay? And now they feel like they were discriminated against, but they didn't sue me for 4 years. Okay, they go to court. My first objection to their case is, look, they're outside the statute of limitations. They have to file within a certain period of time in order to move forward. So courts have said, well, a good plaintiff's attorney is going to be like, did you post? Well, I didn't post my notices. And courts have said, well, if they didn't know their rights, how did they know when they're supposed to file? Okay, so now they can go ahead and proceed to file that lawsuit, and you're going to defend it, and now you may have to defend it from 5 years ago. Your employees may not even be there anymore that were there at the time. And now you got to fight that lawsuit. You could have got kicked out by having the posters posted. So it actually does matter when you're running your business. And the average cost to defend a single plaintiff case to trial is about $100,000, which can put you out of business. So don't let that happen. Sir?
Isn't it easier to just give them a copy of the posters?
You have to physically post them at the location.
In addition to
Yeah, I
posting.
would. I mean, I think it's a good idea. It's kind of cumbersome because, like in California, you have 19 postings, and then they change. So California just recently had a change in their posting. So it gets cumbersome. But yeah, I mean, I like belts and suspenders. So if you can do both, so I would do that if you could. But having it physically there is good enough. So your federal poster minimum wage, your EEOC notice, OSHA, FMLA, USERA, and EPPA. 1 minute, okay. And you can get them in Spanish and English. Most of the posters. When do you need to have it bilingual? When do you need to have it in a second language? Basically, if a lot of people that work for you, I'd say 51%, Spanish is their first language, English is their second language. You probably want to post both the federal poster in English and Spanish. You don't have to, but you should. Who's going to count? You're protecting yourself, and you're just putting up the Spanish version of the poster. So you don't have to worry about somebody saying, I couldn't understand it, especially if most of your workers, their first language is not English. And they have it on the federal side. They have it in different languages, too, Mandarin and other languages as well. I'll skip past the state poster stuff. This is just a quick graph to see how many postings you need. So, like I said before, California, you have 19 postings, and it's 7 different agencies. So you're not going to waste your time looking up every agency and getting that poster downloaded from the web. It's just a waste of your time. You've got to focus on running your business. And we're not going to get enough time to go through the statutes, but you've got to be aware of the federal statutes that affect you as an employer. Title VII, discrimination. For those of you in California, California is very employee-friendly, and their statute is broader than the federal statute, protects more classes of people, and it covers more employers. It goes down to 5 employees, when most of the federal statutes are at 15 or 20 or even 50 employee count. Okay? Are we doing on time? Yep.
We had multiple people online asking where do they get the posters?
Okay. There are providers. Actually, Intuit has a labor law poster option. They sell posters, and they sell a subscription service around posters. You can get them from other providers in the market. Resellers have them, like your superstores have them. I would go with the subscription model because you basically buy it, you're set up for the year. Anytime there's a change, Intuit automatically ships you the poster that changed, and you don't have to think about it. Okay? So, any other questions here?
And this is a lot of information. You'll have access to get to this information following the event. So hopefully you didn't feel like you had to write down everything because, Michael, it's a lot of information. Thank you for going through this. But you will have access to see some of this information. If there's other questions, we'll have an email address that you can submit questions that we can try and come back and answer questions later on. So thank you very much, Michael. Really appreciate your time.
Thank you all. Appreciate it.